Good morning, everybody. Welcome to our October 7th, 2015 meeting. We'll start with a review of the minutes of our public session from our last meeting of August 4th, 2015. Are there any comments or questions about the minutes?
Yes, Dan, I have some questions, if that's okay. And they're directed to Commissioner Romeo. On page 3, Mike, you spoke about that the commission should micromanage the process of hiring personnel.
Should not micromanage.
Yeah, should not micromanage.
Should not.
Yeah, I'm trying to get a better handle on what you were actually talking about at that point.
Well, it's a combination of, I guess, of different items as far as the staff itself being able to do the job that they were hired to do. And if part of it is hiring some of the other staff members where we have vacancies for daily jobs that need to be filled, that they should be filling them.
You know, to continue on this line,
What line are you talking?
it's on page 3, Marvin. It's the second full paragraph. On this particular point, back in April, in the minutes when we were discussing the $1.2 million increase in our appropriation.
George, can I just interject? Do you have a question
I do have
about the actual minute?
Actually, I have.
Because we're talking about whether or not I'm happy to listen. I just want to make sure that we ultimately get to whether we need to make a comment or a change to the minutes.
Well, I think the point is relevant here, Dan, and then we can move on to the rest of the meeting.
So, do you have a change? Are you proposing a change to the minutes, George?
I'm trying to get a better understanding of the minutes.
Well, the minutes, I think, at this point, it's a reflection of what was said at the August meeting. If you've got other points you want to make, I'm sort of happy to obviously to listen to what you have to say, but I want to make sure that we can proceed in an orderly fashion. We have a very, very tight agenda today, and obviously, you always have cogent and insightful things to say. But at this point, I just want to ask the commissioners again, are there any comments or proposed changes to the minutes from our meeting of August 4th?
Well,
Okay.
Dan, let me ask this.
If there aren't any, can we...
Dan,
pardon me, George?
May I ask a question then? May I ask a question of
Well,
you?
can we...
No, just a simple... Dan, a simple question.
Sure. I'd like to, if there are no comments about the minutes, let's just get the minutes dispensed with.
Well, this
That's
is
all.
what I'm trying to ascertain. I'd be happy to put off the questions that I have, provided we will do it in the public session. As long as I have a number of questions, and they relate to this point, and I'm happy to proceed as you are proposing, as long as we can
That's
take
fine,
care of it.
George.
Okay, good.
I fully expect that you're going to want to bring some issues up on this point. Again, I'd like to just proceed, in an orderly fashion because we do have a rather crowded agenda today. So if there are any questions or comments about the minutes, let's raise them now. If there are no comments or proposed changes to the minutes, I'll entertain a motion to adopt those minutes. With the second, please. So moved, Arroyo. Is there a second?
I'll second, correct.
Judge Correct. All in favor of approving the minutes from the August 4th public session, please raise your hand.
Okay, I counted 8.
Okay.
Deb, you got 8. Can you raise your hands again?
Yes.
No, now I'm not.
Okay. Are there any commissioners opposed
9, okay.
to approving the minutes from our last meeting? All right, the motion carries. George, I'm happy to go a little bit out of order, and I suppose we could take up whatever it is that you've got on your mind at this point.
Thank you very much, Dan. So I want to continue with Commissioner Romeo, and if he can't answer the questions, maybe you can assist, going forward. But, when I was reading this, it reminded me of the April minutes where we were promised a spending plan for the 1.2 million. I was wondering, Mike, whether you have ever seen that spending plan.
I have not.
Dan, have you? Or does it exist? Does anybody know whether it exists?
I don't know, George, and to be honest with you, you as usual are far more up to speed on what exactly was in the April minutes. But anyway, let's get to your point. What is your point, George?
Well, my point is on drilling down to how we're spending money and how we are hiring people. Okay, the minutes said there was going to be a spending plan. There was going to be it was going to deal with staff. It was going to deal with technology, and any other items that came up. Obviously, no one has seen that. But the one thing that we have seen is a large number of hires that have occurred. So, in particular, I'm focusing on the higher paid, the lawyers that have been hired, Dan. So, in that regard, and given that we are a public ethics agency, I was wondering what kind of process we actually went through when we went and hired the new lawyers.
So, Chair, if I may.
Let me say a couple.
I have a similar concern.
Sure, Monica. Let's hear from Monica.
Okay, so
obviously, as the commissioners know, let's hear from Monica.
Sure. All I wanted to say is that we absolutely do have a spending plan that our Director for Administration, Steve Boland, has prepared that spending plan. And of course, if anyone wants to see a copy of the spending plan, we can make that available. All of the hires that were done were in accordance with that spending plan, which covers both what our plans are for technology investments as well as for filling positions and what positions are vacant, and anticipating as well as for this year what we will be spending, as well as anticipating for next year, assuming that our budget stays the same, what we will be spending. So the
staff approved that? Did any of us approve that?
We've always operated under a spending plan. I don't think the commission's ever approved the spending plan before, but again, if the commission wants to see the spending plan and wants to approve it, that's fine. But I don't think we've ever presented a spending plan to the full commission before.
It's generally been shared, since the administrative committee was disbanded, it's generally shared with that group. But let's drill down to the hiring process. I mean, where were the jobs posted for the 3 lawyers that we hired?
All of the jobs that we have hired have been posted on our website. We've had vacancies posted on the website for months, I think, from dating back to maybe even January for various different positions. We've received hundreds of applications for all of the positions that we've filled over the last 9 months. And some of the people who apply for council positions were fit and have been sitting at this table filled associate council positions, and some of them have filled more senior staff positions. So the positions have been up and posted, and like I said, we've received hundreds of resumes.
Okay, how many people were interviewed for each of the 3 positions?
I don't have the interview numbers with me right now, but we've interviewed.
For these 3 positions?
We didn't sort of interview position by position. We interviewed for all of the positions and vacancies as they arose.
How many lawyers would you estimate have been interviewed in the last 3 months? Immediately prior to...
Well, the last 3 months the positions were filled, so I mean, if you would go back to January...
No, I'm not going back to January, Monica. I'm going...
last 3 months...
You actually, I think, let's not truncate this. It would be helpful, I think, to everybody, rather than focus on any particular period. Why don't you walk us through, as best you can, the process, the kinds of qualifications that you've looked at, the criteria that we've used, whether it's in the last year or so or historically, now that we're having this discussion. Go ahead, Monica.
Wait, just 1 second. I think what the problem is here is that we have an administration committee, and it wasn't sent to that. Plus, the statute indicates that the commission is supposed to do the hiring. And so my question is, why wasn't it sent to the
Okay, so
administration?
let's answer the question. Number one, the statute provides a process with respect to the delineation of responsibilities between the commission and the staff, and there is a long-standing authority that this commission gave to the staff with respect to hiring. At times, the commission has had members of the commission perform an advisory function in the staff management of day-to-day hiring decisions. That committee at various times has met. There have been people who've been on it. There have been people who quit. But I'd like to have Monica walk us through the process, because George has asked, I think, a good question, and I think it deserves, a full answer. So, Monica, could you?
And then you'll get to my question.
I answered your question,
No, you
Judge.
didn't, but
I
you'll
did.
get to
But
it
you know what,
afterwards.
Judge? Let's have Monica answer the question, and then we can proceed.
Dan, may I add one thing before Monica
No, actually,
starts?
I want to hear from Monica, if you
But
wouldn't mind, George.
but
Can you
Dan,
answer my question, please?
Dan, the point is, I'm not worried about what happened from December of 2011. I'm really focusing on the last 3 or 4 months. Okay? Because that's where I seem to.
I hear your point. I understand that point, and it's a good one. But, like you and like the judge, I've asked the question to the staff. I'd like to just get an answer, and then we can move forward. Go ahead, Monica.
Okay. I mean, historically, for the time at this commission, and this process hasn't changed, as far as I understand it, since I got here and we began filling staff positions. We post for those positions, both on our website and on the state website, and we also take resumes that come in from either commissioners or from anyone else that we know. We do outreach, ask people to send us resumes, et cetera, et cetera. All of those resumes are now kept centralized in our G Drive, and for each position. And then depending on the nature of the position, the relevant supervisors will take the lead in culling through those resumes and identify candidates that they want to interview, and then they will interview all of those candidates and identify their top candidates, and then depending again on the position, if the relevant director wasn't involved, they would then meet with those candidates as well as possibly me and or the executive director, and then a decision is made as to which candidates we would like to hire. And from then, once we have that decision, I handle the negotiations and checking the references, working closely with the executive director in terms of making salary decisions consistent with the staffing plan that the commission approved back in February 2012, and which was later modified in 2013, and so on as we've gotten more money. With respect to qualifications, we always look for the most qualified person that we can find with a personality that we think will fit, that we obviously are impressed with during the interview, who has good references and has a good suitable job experience for this agency. We also have balanced, I believe, how many people we hire from the private sector and how many people we hire from state government, federal government. We have a mix, and from local government. So overall, we have a pretty good mix among all of the different components in each of our different divisions. So, I mean, that covers our general hiring process. For almost every position that we've had, upwards of 40 plus applicants, probably higher than that, but I don't actually have those numbers. And in filling all of our council positions, I've done, along with I can't really speak for how many interviews the directors may have done, but myself, I participated with respect to legal staff in easily, I'd say, 40 plus interviews over the last 4 years. Probably a lot more than that, but again, I don't have those numbers in front of me. And in filling all of our vacancies that we have right now, we have been engaged in that process since last fall, because over the last 12 months, gradually, we've had, some attrition, and different people have left and moved on. And so we've had the positions posted for a long time. We've met with lots of qualified candidates. And so, when one attorney leaves and we had a posting and we received dozens of resumes or more for that position, obviously I kept good people in mind. So as I filled one, I might then fill the next vacancy with another one of those good people, and so on and so forth. And to answer just Commissioner Weissman's question, the reason I'm having a problem with your 3 months is all of the decisions were made before the end of July, and so nothing really happened in the last 2 months, and really most of the activity happened in the last, in the 9 months preceding July, when the decisions were, the final decisions were made. So this process has been an ongoing one for months and months and months, and it just expanded when we got more money.
Okay, then let's get specific. We have a title that we went through last time. Special Counsel and Chief of Staff. How many people were interviewed for that position?
I would include that everybody that we've interviewed has been in mind for that particular position, because we're always looking for, as soon as we realized that there were going to be vacancies, we've been trying to fill them.
I think we got a chicken and an egg here problem, because the position never existed until we showed up at the last meeting.
I disagree. I held the position.
No, special. You were a special counsel?
I wasn't special counsel, but as we discussed at the last meeting, the secondary titles have never been, until you raised the issue, have never been significant. And actually, at this point, we now have 3 people who hold the special counsel title.
Yeah,
So,
Monica,
go ahead.
Marvin, let Monica finish her answer, Marvin. I see your hand. Let's just let Monica finish. Thank
Are
you.
you finished, Monica? May I?
I think I'm finished. I think obviously the chief of staff position is a unique position, and I think, in thinking about those particular positions and how we want to fill them, you're looking for very particular qualifications. But anybody that we've interviewed are people who we consider to fill all of the different vacancies that we've had.
Okay, Dan?
Yes, Marvin, you have the floor.
Okay, I just want to put a little emery to this, because you're general counsel, and I asked you earlier,
Yeah, could you speak closer to the mic?
where is the mic? Over there? Last week or so, I asked Monica to send me the particular resolution of the commission which took place in February of 2012, in which delegated authority was given to the executive director to accomplish the hirings. And when I looked at the resolution and looked at the statute, I found a stark difference. It seems we've become all too liberal with this delegated authority. The statute merely says that the commission may delegate authority to the executive director to act in the name of the commission between meetings of the commission. That's all it says. Between meetings. Between meetings is like an executive committee acting between meetings of a board. Now, when you look at the resolution, it doesn't use any of the language of the statute. It merely says to delegate authority to the executive director to appoint staff as necessary to carry out the responsibilities of the commission. That's nowhere stated in the statute. In other words, the commission hasn't given away all its authority to appoint staff. If the executive director was sitting here today during a meeting of the commission and wanted to appoint a staff member, obviously, the executive director could not do so. If the executive director found it necessary for some reason to appoint staff a day before a commission meeting, between meetings of the commission is a term of necessity. Now, if you disagree with me, Monica, I would like a written opinion from you. You're general counsel to this commission. But the point I'm making is, when Letitia called me, as she did others, to advise that she was leaving this commission, it was, of course, the first I had heard about it. I had no knowledge that she was even intending to leave, or she was negotiating for another position. And I doubt that most, if not all, of the members of the commission had any such knowledge. So, in the same conversation, she told me that she had just made a number of appointments of people I knew nothing about, and she didn't show up at the next meeting of the commission, so I was unable, no, the commissioners were unable to ask her anything about these appointments. So here we are, as George has been elaborating a bit about, with people who are hired by a person who's 1 foot out the door, appointments that could have awaited a meeting of the commission. There's no necessity. I saw no statement of necessity for doing those hirings between commission meetings. But I again emphasize the notion that this delegation to appoint staff is as necessary to carry out, necessary in whose opinion? That's not the language of the statute. So I think it's very important, as George says, to get behind, to drill down how these things happen, when were they discussed, who was interviewed, when was this posted, what other people were considered, and I have a lot of trouble with this because these appointments were not of positions. For example, special counsel, chief of staff is nowhere on that chart. And what happened was, you used the chart as a menu. You took Robert Cohen's special counsel's designation and your chief of staff designation, and you put them together and you created a position. We never delegated you to do that. The chart is not a menu. And the reason the delegation is in this statute is because once the commission approves who's on the chart, the delegation can operate. But we never approved a position. Chief of Staff, Special Counsel. We approved Chief of Staff, we approved Special Counsel. But whoever authorized you or anyone else on the staff to take these two positions and merge them and create a new one and assign to it a salary which pays more than anyone else on this commission. So I'm having trouble with it, as George is, and if your position, Monica, is that I am somehow misreading the statute, misunderstanding the delegation by resolution, and give us an opinion, a written opinion, as in the corporate world, when the general counsel takes a position, and that position is as specific as you have said it, that all this was authorized, that's on the chart and all. I'd like to have a written opinion that explains the law, explains the resolution, and tells us why, under the facts of what happened here, all of this complies with the statute. A written opinion.
Commissioner okay. Sorry, Mark, I think we're finished. No, there are a couple of other commissioners here in New York who were looking for the floor. Sorry. David or Dawn?
Yeah, sure. This is David. I wasn't on the commission in 2012. I'm not familiar with the resolution that folks have been alluding to, so I'm not knowledgeable about what the delegation may or may not have provided. But we're sort of stepping back here for a second. Do we as a commission really want to be involved with the hiring decisions that are made by the leadership of this body? I mean, we hire people.
What's the leadership?
Well, the executive director, the general counsel, the management, if you will, the C-suite, if I can draw an analogy, the corporate sector, which was brought up a moment ago. I would think that we hire people at the senior positions, including for the executive director position, and in doing so, we are placing confidence in that person that they're going to go about staffing this commission in a way that's in its best interests and applying the criteria, which to me seemed sensible, that Monica articulated a bit a while ago. And so, again, without getting into the weeds of what the delegation provides, I'm having a difficult time understanding why we would want to be involved as a commission, whether as the full body or an administrative committee, in making hiring decisions that, in my view, are sort of rightfully within the scope of responsibilities of the senior staff. That's my point of view. Certainly, obviously, statutorily, the executive director is something that we should have a say in. I'm not indicating that for certain senior positions we shouldn't be kept well informed, but I also am concerned about our establishing some rule that would require all hiring decisions to make its way through this commission. That's my point of view.
Thank you, David. Dawn Smalls?
So let me just affirm and put my agreement in with what David just said in terms of the commission not being the right body to approve all hiring decisions. That being said, how I interpret the discussion is around what hiring decisions. There is a disagreement about what level should the commission approve versus what level should be completely delegated to the staff. So to me, that is the core of the issue. I wasn't on the commission when this delegation was made, but I assume it's not a constitution. We can revisit it. And so rather than having extended discussion about what was the intent, what the delegation provides, there's clearly great discomfort in this body about how hiring, some hiring is done and at what level and for certain positions. So in the interest of charting a path forward rather than looking back, I would just put forward to my other members of the commission that maybe we should actually have that conversation, revisit the delegation, put that on the agenda, and talk about what we have a comfort level. My line would probably be beyond just the executive director, and it seems like there are other commissioners that would want to have some input into the senior C-suite positions on the commission. I think we should have a clear line of what that is so that we're not revisiting in every commission meeting the staffing chart and specific hires that have been made. Staff should feel fully authorized and empowered to make the decisions that they are empowered to do and not have to feel that they have to litigate in many ways, because it feels like that every hiring decision that they make, but have a very clear direction about what they are authorized and empowered to do and what they are not. And that's our job. And so if the delegation was the right delegation at that time but is no longer the right delegation at this time, I would put forward to the commission that we should revisit that. With regard to the staffing decisions that were made in the last 3 months, I understand there's great disagreement about how and whether it was authorized under the previous delegation. I would just offer to my fellow commissioners, what is the path forward? Relitigating what happened and how and whether it was authorized. These people are in place. And so if there is not a remedy or an action that we are seeking to take regarding these hires, I would offer to my fellow commissioners that it's time to move on. And so I don't know the answer to that. I'm not saying that with a view towards one way or the other. I would just say that I would appreciate understanding from Monica, there is clearly some objection in the commission about recent hires. That is a fact. And so with the objection of recent hires, is there a recourse or a remedy? And if not, let's move on.
I think there is, and let me say a couple of things.
Could I speak?
Actually, I'd like to just make my point, if you don't mind, and then I'm happy to hear from you.
Sure, it's not
This,
to do that.
I'm sorry. At this point, well, we have a crowded agenda, as I said,
I'll
Rainey,
bring
and
Robert's rules next time.
okay, no, that's fine. So here's what I'd like to suggest as a way of moving this forward, and I thank you, Dawn, for framing this as a moving forward, a question of us moving forward. So clearly, this discussion this morning picks up on some of the points that were raised at our August 4th meeting, and in particular, I was, I think, very persuaded by the points that Senator Rath made about the agency now being in a state of some maturity as opposed to where we were when the original delegation was made back at the beginning of 2012, when the agency was in its infancy. And so I think that, and I've spoken to a number of commissioners offline about this, and I think what we need to do, I do think we need to have a discussion about this, and I think that is a way of framing these management issues, the role of commissioners in the operation of the agency, the allocation of resources within the agency, and I include within that the allocation of human resources as opposed to dollars and cents, that we need a principled and deliberate process to consider these questions. And so, as I said at the last meeting, I'd like to put together a subcommittee to begin to think through these issues, to help frame them for us as a full commission. And I want to thank Commissioners Arroyo, Senator Rath, Commissioner Smalls, for volunteering to serve on this committee. And I think that we'd like to get that committee moving as soon as possible. And so
Excuse me,
I'm going to leave it to them
I raised this on August 4th. You asked to defer it. So I came here today, objected to the minutes of the public session because it did not contain that deferral. And now we come here today and you're sending it into a subcommittee. I have a simple motion to make so that we deal with it here and now, because we put it off from August 4th, today's October 7th. It's 2 months. Life is shorter than you think, Dan.
what's your motion,
My
Commissioner
motion is
Jacob?
simple. We have no executive director in office. We ought to begin from the beginning. Let's revoke the delegation because it would have no impact without an executive director, and then have a discussion as to which levels should or shouldn't be delegated. For example, Dawn was saying exactly what I was suggesting. At the director level, for example, should we have delegations below the director level, below levels such as the chief of staff? A director is a high-up position. People work for the director. But anything below director may be an appropriate delegation. I'm sympathetic with the notion that we don't want to sit here approving every secretary or typist that comes on staff. But certainly there are major positions. You've worked in a DA's office. I've worked in government. We've all been there. We can't be busy with minor positions. I apologize for calling them that, but in this context, it's minor. So my motion is that for the moment, before the subcommittee even does its work, let's begin from the beginning. Let's revoke the delegation of February 2012, and let's begin a process, as you suggest, to determine at which level should the delegations in the language of the statute occur.
Is that a motion?
I'm not
It's
sure.
a motion. It's my motion.
Second.
Okay, I'm not sure that.
Shall I reword it?
understand the motion or what? Well,
No,
Chair-
revoke the delegation.
Chair,
I'm sorry, I'd like to
can I
hear
ask a
from
question
the
for clarification?
Yes, you can.
Commissioner Jacob?
But not.
Is your motion applied to the entire delegation or
Yes.
just the delegation with respect to hiring? Because I just want to make sure for everyone who doesn't have the delegation in front of them.
For the moment, we ought to do this a piece at a time. On the hiring is what I am talking about.
Just the hiring. Okay, so I just want to clarify, because again,
No,
not
that's a
everyone
good
has it
point,
in front of
Monica.
them.
Very good
The
point.
delegation covers the day-to-day operation of the commission and every function that staff performs, from processing, administering, lobbying filings, processing, administering, financial disclosure statements, audits, reviews,
We know that,
investigations.
but that's academic at this point.
No, I know, Marvin, I'm sorry, Commissioner Jacob, I know that you know that, but not everyone understands that. So I just wanted to make sure everyone understands. The delegation is one resolution that covers everything. So the clarification then is that the motion just refers to the hiring.
At the moment, the hiring. I think we ought to take it a step at a time. We have no ED. We may not have one next meeting as well, although hopefully we will. But at this point, the subcommittee ought to operate within a framework. And they ought to be given.
Okay. So let me just make sure I understand the motion. So you're amending your motion so that you are proposing, as Judge Ross said, to revoke the delegation with respect to the hiring until such time that the subcommittee reports back to the full commission.
And
Is that
to
what
be
your
more
motion
specific,
is,
it's
Marvin?
paragraph 1 of the resolution of February 2012.
I don't think anybody has that in front of them.
Okay, I
so,
happen to have it. I give it to anyone who wants it.
Well, I think as staff, it doesn't matter. Somebody ought to read it into the record.
Shall I
Pursuant
read
to
it?
Executive Law 94-9B, the authority to appoint staff as, well, let me read the whole thing. It says, it's resolved that the commission delegates authority to the executive director of the commission, the specific powers and duties enumerated below. Number 1, pursuant to Executive Law Section 94, subsection 9B, the authority to appoint staff as necessary to carry out the responsibilities of the commission consistent with the staffing plan reviewed and approved by the commission pursuant to Executive Law Section 94, subsection 9B-1. Your motion is to revoke or suspend that delegation pending review by the subcommittee and a report back to the full committee.
I will accept
Is that what the motion is?
Yeah, I would accept your language, yes.
Okay, all right. And Judge,
fine.
you seconded the motion.
Right, and I've been waiting.
Yes, you have. You've been very, very patient, and I'm trying to, I want to make sure everybody gets heard, but as I said, we have a very, very crowded agenda today. So why don't you go ahead?
Okay, as quickly as I can. I appreciate the fact that most of us are not going to read a collection of resumes for, as Marvin put it, minor positions. But that's one of the reasons why we have an administration committee and an investigation committee, so that some of us who are able to take the time will look at these issues, and in the case of the administration committee, the resumes. I think we ought to go back to that process. I think it works for us. It worked for us with a number of issues on the investigation committee, of which I sat. And I think if there are a few members who are interested in looking at these resumes, more power to them, and I'm grateful to them. I think there is an undercurrent here of dissatisfaction from a number of us. And I think that has to be addressed because the commission can function effectively and efficiently if there is that problem. Excuse me. So I was unaware that there was a subcommittee with respect to looking at this issue. I do not see it, or did not see it in the minutes. Did I miss that?
No,
Mr. Chairman?
I don't remember whether it was in the minute.
Well, it's not in the
I
minute.
thought it was pretty clear.
Well, I know, I didn't, but
But
may I volunteer?
Okay, well, thank you for volunteering. In any event,
Does that mean I'm on the committee?
anybody who wants to serve in the committee, should give me a call.
Thank you, I
let's-
just did.
Let's take, wait, is that Mike Romeo?
Yes.
Are you volunteering for the committee, Mike?
No, I just wanted to make a comment and respond, since this kind of started with, I guess, George talking to me
Sure.
about my minutes from a few moments ago, or months ago. And yes, George, I can speak for myself, all righty? I've been involved in many, my own business. I have 40 people that have been underneath me of a 400 company employee company that I work for. I've sat on many boards before. This is the first board that I've sat on where the board wants to get intimate with a lot of the daily goings on, business dealings that happen and come across the commission, the hiring of people. It's just something that is very poor for staff morale. Even calling a minor position, not to offend anybody here on the board or comments that have been made, but even that kind of an outlook towards the employees, right down to the receptionist, that's not a minor position. That's a very important position for the commission. All the positions are very important, and we should empower the staff to do the job for what we hired them for, and let them do their job. Yes, we should oversee, but we shouldn't oversee to the point where we're calling staff and they're afraid to make a decision and do their job and prevent them from doing their job. And that's my point, and that has always been my point. I know there's many on the committee or this commission that disagree with it, but without a good staff, without a happy staff, the business of the commission is not going to go very well. And that's all I have to say about that.
Well, Mike, while you were talking, your chairman, your CEO, your president, your vice president got replaced. What do you got to say about that?
All right, come on, guys. Let's. I think I want to make sure that everybody's had a chance
Dan?
to speak, but
Yeah,
I do want to
question-
wait, David. But I do.
My only question is,
we do have a question.
does Monica have any objection? Are there any hires that in the next, if this process takes 2 months, where this is going to cause a problem to the staff and carrying out its responsibilities, or are you fine in not making hires in the next couple of months until this, if we were to adopt Martin's motion?
I do think that the very fact that it's going to take a few months highlights some of the problems with being able to function on a day-to-day business with vacancies in positions. Obviously, given this discussion, we're not planning to fill any positions. We don't have an executive director at this time, but I do think that's a real issue that Commissioner Royal raised. We do have vacancies throughout the agency that need to be filled. We have resumes and an ongoing process, and whether or not you're going to make a distinction about the substantive role that certain people fill, as Commissioner Romeo thankfully pointed out, in making these decisions, I view them all as very important decisions, and we have a lot of important roles to fill, ranging from filing specialist to auditor to the investigator and to attorney. So I do think that's something that in this committee should also give some thought to, is the ability to fill some of those vacancies while this process is ongoing, because
How many are there?
Right now there's about 6.
Well, I would suggest, and it's a good point, we have a meeting in 3 weeks. I would ask that the subcommittee get together, speak to the staff, determine whether there are any immediate needs, and make a recommendation to the commission for our October 27th meeting as to how to proceed. One of the issues that overlays the work of the subcommittee in this issue, of course, is, and the relationship between the commissioners and the staff, is that, we have a timing situation where we've got, a number of, probably half to maybe about half, a little bit less than half, of the terms of commissioners that are about to expire toward the end of the year. And so we have decisions to make potentially on the staffing questions beforehand, on the one hand, but on the other hand, I would ask the subcommittee, and to the extent that, we've had volunteers, including the judge here, we've got, a number of people who are going to be, whose terms are not ending, so that we really need to be focusing on, where we want to be, to the extent that we have a number of new commissioners, or, if folks want to get reappointed, they do get reappointed, but the potential is there that there could be a lot of new faces around this table come January. And as the committee works, I would suggest that the committee needs to be mindful of the fact that, we could have a very different face, different composition of the committee. But going to David's point, I would ask that the committee, the subcommittee, give immediate consideration to any imminent staffing decisions that need to be made and come back to us with a recommendation for our October 27th meeting. Okay. Can we now take a vote on Marvin's motion, which has been put before us and seconded?
Before we take a vote, Dan, on Marvin's motion, if I understand the delegation, only executive director can hire. If we don't have an executive director, I'm not even sure what Monica was talking about.
Well, they have to come back to the commission.
To the commission is fine.
Which is the contemplation of the statute.
That's exactly
what you
George.
said.
That's exactly
Okay.
what you're doing. The motion, George, Marvin's motion says, there's nobody on the staff who can hire anybody.
That's right.
Any hiring decision at this point would have to be made by the commission.
Of course.
Which is why I said I would like this subcommittee to get with our staff and find out, are there any imminent hires that need to be made so that we can consider those at the October 27th meeting.
Correct.
Right?
Yes.
Okay. All right, can we take a vote? All in favor of Marvin's motion, raise your hand.
That's I think.
We're voting on Marvin's motion.
Yeah.
I see not 10. What do you have?
I don't know about.
All right, Monica, do you have the ayes? All right, any opposed to the motion?
Yes.
Raise your hand. Commissioner.
Commissioners Rosen and Romeo.
Dan, if I may, before we leave the point.
And Dan, I'm not
Wait,
done
I just
yet.
want to, yes, Joe, but wait. I just, did we get Commissioner Renzi's vote? Dave, I didn't see your hand, I'm sorry. I don't mean to put you on the spot, but did you vote? Dave Renzi? All right. I don't know if we can, maybe it's a technology issue, but Monica, did you get a vote for Commissioner Renzi?
Yes, he voted in favor, so it carries.
Did, okay, all right. Joe, did you want to make a point before we move on to?
I just wanted to make a
Yes, the
comment.
motion, yes, I thought I did say that. What? The motion carries. Okay, all right. Joe, did you want to make a last point before we move on?
I did. In response to something said earlier, we were looking for general counsel for a series of years, and we even fought about whether general counsel will report to the executive director or report directly to the commission. And lo and behold, we have a general counsel, and the search was underway as far as I knew. But totally changing gears and totally flipping, I just want to point out when this midnight hire was made, Monica was not the executive director. And Monica is sitting here very professionally, taking a lot of what's being said as if it was her actions, and in defense of her, it wasn't. So I just wanted that out there and on the record. And Monica just smiled at me. I think she gave me $5 or $10 for saying that. Seriously,
Under 15,
she was
Joe.
not
is that a violation?
And she's
Under
too
15,
professional
Joe.
to defend herself by saying, it wasn't me, guys and gals. You know.
All right,
Dan,
well, thank you,
Dan,
Joe.
Dan,
Thank you, everybody.
Dan, I have one more point, because Marvin went on to the delegation. But I have one more point, and it's granular. I'll admit it, but it goes to the heart of what happened here. After the meeting, I took the opportunity to look at the resumes. I do have a question for our general counsel before I go on. Are the resumes of the people who were hired, are they available to outsiders?
No.
Why aren't they available to
I
outsiders?
think Monica, George, I obviously want to indulge whatever is on your mind, but I also want to ask our general counsel, I want to be mindful, that we can have generic discussions about personnel matters
This is
in the public session, but let me just ask Monica,
Okay.
I want to make sure that, to the extent that there are personnel matters that by law we cannot discuss publicly, I just want to make sure that we're on the right side of that question.
Okay, well, Dan, generally under FOIL, putting aside how it's been interpreted and applied to this agency, employees once hired, their resumes are available. Okay? So let's leave it at, now you can ask Monica the question, or Monica can answer my question.
No, that's fine. I mean, let's just make the point, and Monica is a response, and I would ask the commissioner's indulgence to move on, because we do have...
Yeah, I know, and I will make my point quickly, Dan, and then move on after Monica answers.
I thought you already made your point, George.
No, I didn't. I actually didn't.
I thought
Dan.
that was the point.
No, it isn't.
My answer is that we have never before made resumes publicly available. We are, as you know, not subject to FOIL, and resumes are not one of the items delineated in 94 that is to be publicly available. And consistent with our interpretation and practice and application of that law, this is not the kind of thing that we have made publicly available. And I'm not aware, and I'll have to, consult with Bob Freeman and so forth about the fact whether resumes are made available. I'm aware that often some agencies put bios and make them available, but I could think of a lot of reasons why people's resumes, which contain a lot of personal and historical information, including years and addresses and where they lived and when, should not be publicly available.
Unwarranted invasion of personal privacy would take out home addresses, Monica. I will be happy when I get home to send you case law and the Freeman opinion on this matter.
And that's fine, but again, we are not subject to FOIL, and that is not one of the items identified under statute as something that should be publicly available. If the commission wants to discuss whether we should, make bios on some senior staff available, that's certainly something that we could do.
Well, let me make my point, Dan, and then I'll move on. I had, after the meeting, I had the opportunity to go through the resumes, and what truly troubled me was the way, in terms of hirings, that it seems that we hired 3 people from the same office in the Attorney General, who worked together in the Attorney General's office back before 2011. And what I see is a pattern of hiring that may not have gone through a process. It may have, but quite honestly, I don't believe in coincidences. So that's the one point I want to make, and I will move on from this now.
Thank you. And with that, can we now turn, Monica, to item number 3 on the agenda? There were 2 bullet points there, budget and new electronic filing system for SESs.
Sure. It's that, I guess with respect to the first item, it's the time of year again where we need to submit our budget request to the Director of the Division of Budget. We have received what is commonly known as the call letter, a request for us to submit that budget request. And I believe that the submission is due on or about October 16th. Is that right? Yeah. So obviously there will not be a meeting before we need to submit the budget request. Steve Boland, our Director of Administration, is already preparing the materials that we would submit. And what I would request is that any commissioners who want to be involved in the process, let me know, and we can, once we have a draft, share it, discuss it, talk it through before we make the submission. But again, it is due on October 16th. Yes.
And George, I'd like to actually, I know that you have been active in that process before, and you have a great deal of experience from your prior service for the state. I'm assuming, and I'd like you to work closely with the staff on this.
If asked, I'll be happy to help.
Well, I'd like you to.
That's exactly.
It's a request.
Is that a motion?
I don't think we need a motion.
Dan?
Marvin?
Yeah, just a question, Monica. This budget we are seeking approval of, does it contain more positions, less positions, the same amount of positions we now have? Can you just give us the
budget request that we're going to
Yeah.
submit? I mean, we're still working on it. And you know, the letter, I believe, as it has in the past, asks us to, you know, control costs and request that agencies submit requests for flat budgets with no increase. As everyone knows, we got a substantial increase last year of $1.2 million, which under our staffing plan and spending plan would allow us to fill approximately 11 new positions. So at this point, I don't know whether we would anticipate asking for an increase for more positions, particularly since, as I said, 6 of those positions are still vacant. And so, you know, I think that we feel like if we fill those 6 positions, we may be able to meet our needs. But that's part of what the discussion will be over the next few weeks as we finalize the request.
Okay.
All right.
So the next,
you know,
yeah.
thank you.
We wanted to just update the commission on a few things that are going on with technology and other developments. We've spoken before about a redesign of the financial disclosure statement online filing system, and we've been working on this for 18 months. I want to thank Martin Levine and Jen Meisner and other people who have been involved from ITS in this project. But it's been a long 18-month design development project, and lots of other members of Martin's staff have had a heavy role in this as well. And the system is going to make it easier for filers to file and for JCOPE to process filings and do the compliance work. Some of the things that have been manual for years are going to be automated under this new system. And we are expecting to bring that system up and live in the next week or so. The first group that's going to be using this system are the academics who file in November. And so I'll have a good test run to make sure everything is running before the May system when everybody file, you know, the majority of people file. So we're very excited about this and hope it really works well. And that's one thing. And on the same tangent, I just want to remind you, we're also engaging in a redesign of the lobbying system. So we're at the beginning of that process, but our goal is to redevelop that system and we'll hopefully roll it out by the end of 2016. And again, this will address lots of issues and problems that exist in the current system. It'll improve the filer experience. It'll improve the public's, you know, review and search of the material in the filing system. And again, it will improve JCOPE's experience administering and processing filings, automate some of the compliance work that staff has to do, and really make the data that's in there more available in a more useful way. And to follow with that, I should mention that, as I think everyone understands, after each filing period, after every semi-annual period, we update our data on our website. We put up a downloadable spreadsheet with the data that is most recent and has been reviewed and processed by staff. So the information that's been filed with us from January to June of this year, we anticipate that we are going to be updating that data on our website within the next week or two. I think that's it from me.
Monica,
Yes,
are they testing the site before they release it?
yes, they did.
In-house beforehand?
Yes, there was, over a few months of testing?
3 months of testing.
3 months of testing. And that's been done in the course of any changes that we make to the system. There's a regular testing.
More or less than Obamacare.
Let's hope.
Monica, did we get any information from the Moreland Commission's data?
My understanding is that the U.S. Attorney's
That's,
Office took
Got everything?
That's
Yeah.
with the
I figured they
regulations.
had up-to-date
It's the discussion with the regulations.
programs.
Gonna do it today.
We're going to do the
Yeah,
regulations.
my
yeah.
understanding is that they hired a consultant to do a lot of data work, but that the U.S. Attorney's
Oh, okay.
Office took possession of all of that. But I don't know. Chair, I'm done.
Okay. Thank you.
We're going to move.
So let me give folks on item 4 an update on the search for the executive director. So as we discussed at our last meeting, we put together a committee to help with the search for a new executive director and to make sure that we have a careful and deliberative process to make recommendations, obviously non-binding ones, to the full commission. I want to thank Commissioners Jacob, Koretz, Rath, and Rosen for helping out with that. We did have a meeting last month. We have a meeting scheduled for this coming Friday. As we have discussed, the committee is anticipating a nationwide search, and we anticipate posting for the position on Jacob's website and other similar sites, as well as in relevant newspapers. The search committee has discussed and is considering whether to retain a professional search firm, and I expect that those matters will be taken up by the subcommittee in its meeting this coming Friday. Commissioner Smalls.
Is there anything precluding us from just putting the posting on the website? While these other deliberations, I would assume that everything else would be supplemental to a posting on the website, and that we could begin to collect resumes.
We can do that. I think that, the committee made a decision that they wanted to sort of holistically deal with everything at once, and since today is Wednesday and the committee is meeting on Friday, I would expect that perhaps we will be able to have a posting once the subcommittee meets on Friday. So I would expect that will move forward, and I see some members of the committee shaking their head in agreement with me. So we'll get that done. All right. I think that we shall now turn to proposed regulations for an exemption from publicly disclosing client information and financial disclosure statements. And so that, and I'll turn over to Monica in a second, these are regulations that the staff has prepared for our consideration that come out of legislation that the governor proposed and put in the budget for this prior year to expand and make revisions to the financial disclosure requirements for outside income, with an eye toward making those disclosures much more precise, much more fulsome, particularly with outside activities and clients. So, Monica, let me turn it over to you at this point.
Thank you.
Always got it, Marvin.
What's before the commission are draft regulations that staff has prepared that would provide for a process for the commission to receive and consider applications for exemptions from the 3 applicable client disclosure provisions. At this meeting, the first step and what the commission needs to consider is whether to begin a rulemaking process. If the commission votes to begin a rulemaking process, the regulations will be submitted under the State Administrative Procedure Act to be published in the State Register, and then there will be a 45-day public comment period, and then the regulations will be brought back for the consideration of the commission. Changes can be made. If the changes are not substantial, then the regulations can be finalized, but if there are substantial or material changes to the regulations at that point, they will need to go out for another public comment period. As you know, and as the chairman had mentioned, the client disclosures become effective on December 31st, 2015. So our goal is to have this process in place by the beginning of the new year. And in order to do so, that's why we're bringing it to the commission at this meeting. So if the commission does move forward today, we'll be able to complete the process, assuming no major changes in time for January. I'm going to turn the presentation over to John Harford, our Director of Ethics and Lobbying Guidance, who will just talk us through what the actual client disclosure is and give you just an overview of the regulatory process for the exemptions. And then he'll give it back to me, and I will talk through, over the last week since we circulated these regulations, several commissioners have given me some comments on things that they would like to present for discussion among the commissioners. So first, I'll turn it over to John Harford.
Good morning. We thought it would be helpful
Morning.
to provide context.
Morning, John.
Good morning. Provide context for the discussion of the new proposed regulations. Just briefly overview the changes to 73A that occurred in the last appropriations bill in terms of how they expanded the circumstances under which client information must be disclosed by filers, as well as the amount of information that must be disclosed. Essentially, the appropriations bill expanded the client disclosure in 3 ways. As I said, there was an expansion of categories of circumstances in which client relationships by filers must be disclosed. In those circumstances, there's additional information that must be disclosed. And the statute also sets forth more specific guidance as to how requests for exemptions should be handled. Requests for exemptions were always available. The statute now spells out specific criteria that the Commission and the Office of Court Administration must consider when receiving requests for exemptions from client disclosure. Essentially, the amendments were made to question 8 of the financial disclosure form. So I'm going to take them one by one. The first change is the creation of a new section 8B1. Which is essentially a reworking of the old 8B. It requires a filer to disclose client information if the following 3 criteria are met. 1, the filer must have either provided the services to that client or brought that client to their firm or practice. 2nd is that client must have paid $10,000 or more. Can everybody hear me?
No.
Sorry.
Must have paid more than $10,000 or more to the filer or the firm where the filer works. And the business for which they were retained involves state business in some form or fashion. If you look at the old B, it lists, I think, 4 categories of state business. And you can sort of think of B1 as sort of the state business client disclosure portion of 8B, of 8. Insofar as it has to involve either a contract with the state. Previously, that contract had to be for $50,000 or more. That threshold has been lowered now to $10,000. It had to involve previously a grant from the state of $25,000 or more. That threshold has now also been lowered to $10,000. And it has the other 2 remaining categories, which is a grant from the state, which is the product of some legislative initiative, or any business for a client that involves appearing before state agency in a non-ministerial manner. So it's essentially a lowering of some of the thresholds that previously appeared in B for B1. I'm skipping beyond B2. I'll get back to that and I'll explain in a minute why. C previously existed, but it was also reworked in some regard. This, I think, can be considered sort of the lobbyist referral client disclosure. It involves business received by the filer and clients received by the filer that were referred by a lobbyist. Disclosure is required if these 3 criteria are met. The first is a threshold requirement that the outside activity by the filer generated $10,000 or more in revenue. The second requirement is that that filer knowingly accepted a client referral directly from someone they knew at the time was a registered lobbyist. The third criteria is that the filer or their firm received more than $5,000 in fees as a result of that client referral. The third category, which is B2, which I'll go back to now, I put it last because it's, in the way it's couched, it's something of a catch-all. And it is perhaps the one that will create the greatest increase in the number of client disclosures that will have to be made by filers. Again, it has that threshold requirement that the filer's outside activity generated $10,000 or more in revenue. It also has the requirement that in those circumstances, the filer actually provided the services to the client, so it wouldn't include referrals where services were provided by someone else. But it also has the requirement that the services performed for that client generated more than $5,000 in fees. Now, with respect to all of these, the client disclosure that has to be made has increased. For all of them, at a minimum, what must be disclosed is the identity of the client and some quantification of the amount of money that was generated from the services provided to that client. The relationships involving lobbyists and those involving business of the state require a bit more information. They'll have to disclose the matters that were handled for that client and some description of the nature of the services. But for all of these, when that client disclosure is triggered in these sections, they will have to provide the client's identity as well as some quantification of the amount that was earned. The statute also, as I said, expands upon how requests for exemptions from this disclosure requirement should be handled. Basically, there's three components to the changes that were made. Essentially, a threshold eligibility component, where someone who is seeking a client-specific disclosure has to first state clearly, essentially, that the client and the services provided did not involve any of the activity basically described in B1. It didn't involve the state business. It also sets forth the factors that the Commission must consider, it says shall consider, when evaluating one of these requests. And the information in the regulations is designed to notify and advise those seeking this exemption as to what information they're going to need to provide to the Commission or the Office of Court Administration in order for you to properly consider the factors that you're required to consider under the law. So briefly, just the factors. Again, as I said, there's this threshold requirement of eligibility. They must state that they are not, that the client is not receiving or seeking services of the filer in connection with the following state-related business. And essentially, it's all of those activities that were set forth in B1 as rewired.
Why are they seeking exemption?
Here are the factors that the Commission must consider. The nature and the size of the client, whether the client has business before the state, and some description of how significant that business is. Specifically, the client, whether or not the client is interested in pending legislation and what the significance of that legislation would be. Some indication as to whether or not disclosure would reveal trade secrets, whether disclosure could reasonably result in retaliation against the client, whether disclosure may cause undue harm to the client, whether disclosure may result in undue harm to the attorney-client relationship, and whether disclosure may result in unnecessary invasion of privacy to the client. As I said, there was previously a provision for seeking an exemption to client-specific disclosures in the form. However, it generically referred to setting forth some form of harm that would come as a result of the client disclosure. Here in the statute is set forth specifically sort of enumerating the types of harm it expects the Commission to consider in considering whether or not to grant an exemption from this client disclosure requirement. The regulation that's been prepared by staff includes in it an attempt to sort of list the type of information, as I said, that a filer would need to provide to you in order for you to properly consider all these factors.
Thanks, John. So I'm going to take you back to the actual regulations that were presented to the Commission that were drafted by staff. And as John mentioned, the process that's created in the statute, which was done as part of the budget amendments, creates this exemption. So as you all know, there are statutory exclusions for certain types of services, criminal proceedings, bankruptcy, and other types of services. So this exemption process is not for those. Those are done by statute. But this exemption process is for anyone who doesn't fit under one of those statutory exclusions. You still have an opportunity to seek an exemption. And as John mentioned, there are factors for the Commission to consider. They're not an exclusive list of factors. The Commission can consider other factors. But you can tell from those factors that there's some kind of a balancing test between this interest, any interest in the state business that the client may have, and any potential harm that may occur from disclosing the identity of the client and the nature of the client-attorney relationship. based on, we've been, in communication with the Legislative Ethics Commission as well as the Office of Court Administration, because as I mentioned, that this process that was set up to seek an exemption provides that filers can seek an exemption from either the Office of Court Administration or JCOPE. So we've been coordinating and talking to both OCA and the Legislative Ethics Commission as we've been developing these regs and about how the process should work. And based on other outreach that's been done, it's anticipated that filers are going to apply for the exemption prospectively. So the reality is these regulations and disclosures the client disclosures go into effect on December 31st of 2015, which means they're in place for all of 2016. The FDS filing that includes that information will not be due and submitted to JCOPE until May of 2017. But we don't expect people to wait until then to apply for the exemption, because in real practical world, over the course of 2016, clients are making decisions about retaining lawyers, and we expect that those applications are going to come in as part of those discussions, and so people are going to want to know whether or not they're going to get the exemption as part of the client retention determination. So we're expecting and want to be ready to operate as of January 1 and be able to accept these. And my understanding is that OCA, we've sent them a draft of the regulations and they're reviewing them and developing their own process, and we want to coordinate, but I think that they're anticipating to be ready with some kind of process by January 1. So with respect to the regulations, I've talked to a handful of commissioners and received some comments. As I've said, I've talked to others and gotten some comments, and so there are some discussion to be had about changes to the draft regulations that you have in front of you. But if anyone has anything they want to raise first, yes, go ahead. Sorry.
Well, I guess to start, because I haven't heard what anybody else said, but I think it would be helpful, Monica, given the number of lawyers sitting on this commission who are in private practice, to let people know who these regulations cover, because it's going to hit how they deal with clients.
Well, the regulations cover everyone who files a financial disclosure statement. Obviously, it's going to be mostly relevant to people who have outside practices where they service clients. It's not limited to lawyers, but that's obviously the scheme that the lens that we all tend to look at it through. My guess is that we'll have most direct impact on unpaid or per diem commissioners at state agencies who have full-time jobs set aside from the role that they play, like all the commissioners on this agency, as well as the legislative members who often have full-time positions outside of the jobs they do for the state. So, those are the ones who are obviously going to be directly impacted, but it would affect anybody who has an outside business.
Who's going to approve the exemptions?
Well, the way the regs are drafted, the commission, in the first instance, approves the exemptions.
Who is the commission?
JCOPE?
The commissioners sitting at this
in the first instance, have the authority to make that decision. And as we've talked about earlier, there is a delegation. It does not include these exemptions at this time. It did include the former exemption that used to exist, which John Harford mentioned before they made these recent amendments. It did include the client exemptions because that original version was done at the same time JCOPE was created, so it was part of the delegation.
Well,
I will just clarify, other FDS exemptions that exist, exemptions from very specific questions, redactions, in other words, requests to keep information from being publicly disclosed, are handled and have been delegated to staff in the past, and we handle those on a day-to-day basis. So there are lots of different FDS exemptions, but at this point, this one, and as the regs are drafted, it's in the commissioner's hands. And that's something I think ultimately the commission needs to consider, but it's not really necessary to decide that in terms of going forward with the regulatory process.
From my point of view, I think it should be clear in the regulations that it's not delegated. That's just my personal view. So...
Well, it's not delegated until you delegate it. I think that the committee has been set up to separately discuss the issues relating to the delegation, so the commission can choose at a later time not to delegate it, but it is absolutely not delegated now.
Okay.
So that's clear. So you can move forward.
Why would we do it negative? We would have to affirmatively delegate.
Exactly.
Not.
Exactly.
Well,
it's not delegated until you delegate it.
There may be a time where a number of us aren't sitting here. My next question is the actual process, Monica. Do people send in the request for the exemption, and how does that work vis-a-vis how if the request is granted, how does that work via the FDS itself?
So, I'm not.
I mean,
my understanding is if the commission.
Yes, I know.
If the commission grants the exemption, then the client information that otherwise would be required to be publicly disclosed will not be publicly disclosed.
Okay, so hypothetically, I come in and ask for an exemption in February, it's granted. Do I have to actually put it on my FDS, and then you will redact it?
Just like we handle all the other redactions that we get, that's what's anticipated, but you wouldn't file your FDS until May of 2017.
That's what I'm saying, but
Yes. The way the statute reads is it's an exemption from public disclosure, and so these regs anticipate that it would work the same way the redactions work in 94, which we've been doing for years, where people apply to the commission to say that their information that they give to Jacob on their FDS will not be publicly disclosed. So we've been doing that for years.
I'm not sure I read it that way, but others may want to comment on that.
So, and I understand that, I want to make clear, the regs are definitely drafted that way.
Yeah, I know,
Okay.
and I'm not, I don't read the statute that way.
I mean, I guess that's something for the commission to discuss.
Go ahead, Mark. No, I got more.
I'm wondering whether we've thought about the appearances of JCOP commissioners and staff applying to JCOP as opposed to the OCA. Should our commissioners be applying to us? Should the appearances of that seem to be difficult for me to assimilate, as being fair? I'm not saying it's prohibited by statute, but we are an ethics agency, and I can see how at least outsiders would like us to apply to another agency. After all, we control this agency, so to speak. I don't know that you'd know it from watching these meetings, but seems to me the way to go. I don't know what we can do to make that happen except express a sense of the commission itself.
Obviously, that's something else the commission should consider. I will just point out that the other types of exemption requests that exist, those are exclusively within JCOP's purview to grant, and commissioners apply to staff, because those, again, have been delegated. They apply to staff regularly, for whatever exemption.
Which do you refer to, the other types?
Oh, in 94-9H, any filer can request an exemption if they can establish that the information has no material bearing on the discharge of the reporting person's official duties. So we get these requests from filers all the time. And they, Martin, you may know the numbers offhand, but I don't, how many we get. We've never discussed this with respect to our own commissioners. We haven't had that many. But it does, obviously, the same issues posed with those, and with respect to 94-9I, which provides that you can seek an exemption from disclosing information relating to your spouse or minor children if you meet the criteria in 94-9I. So this is, an issue. It's the same, same
I'm
issue.
speaking about the lawyers that who may be sensitive to doing it, but if it's the sense of the commission that we ought to apply wherever we wish, that's fine with me. I think from an appearance standpoint, it makes sense for the lawyers to go to the OCA if they're sitting on this commission.
I think it makes sense to resign. Who needs the aggravation?
Monica, can I ask you?
Who needs the aggravation?
Monica, can I ask you a question? You said that you've had some discussions with the Legislative Ethics Commission, and you've solicited viewpoints from other commissioners and others as well. Can you just bring us up to speed on when you had those conversations and where those stand, please?
Sure. We've been in communication with staff at the Legislative Ethics Commission and the Office of Court Administration for months about just generally that we want to develop this process and about whether or not we would anticipate that people will actually apply prospectively. And then more recently, we drafted and prepared these regulations. We shared a version of draft regulations with the staff of the Legislative Ethics Commission last week, and they gave us some initial minor comments, and then we prepared a version that was shared to the full commission. We then shared that version with the Legislative Ethics Commission as well as with the Office of Court Administration, and I heard back from staff from the Legislative Ethics Commission yesterday, and they do have some concerns about statutory interpretation, and they're not going to be able to prepare. The Legislative Ethics Commission is not going to be able to prepare a formal response yet. They do understand that the next part of this process is to engage in a rulemaking, and there's an opportunity for public comment. But so that's where we are at the Legislative Ethics Commission. From the Office of Court Administration, I think they've taken an initial look, and their initial view is that the regulations seem to be appropriate and reasonable. But again, I'm expecting to have additional conversations with them. I think more people wanted to give them a close look.
Well, I asked the commissioners, do commissioners have a viewpoint at this right now in terms of, do we want to move forward with these regs and begin the SAPA process, or are there folks that think that we ought to wait for the comments from the Legislative Ethics Commission, or to the extent that others have questions, take these issues up at our October meeting? What do the commissioners here think we should do?
Commissioner Weissman has...
We should wait. I thank you, George. I think Eileen Caress has the floor, and since we haven't heard from her today, I'm going to call on her first.
I think that we should wait, since our next meeting is still this month, and hear what the Legislative Committee and OCA have to say if we're going to try to coordinate our regulations, and what their comments are. I don't think we have anything to lose to wait a couple of weeks.
Okay, George?
Yeah, I'll help speed the meeting up if we wait a couple of weeks, because I probably have another 8 or 9 questions.
Yeah, Dan, I would just like to say, I made a joke a minute ago about it would be intelligent to resign. I'm seriously concerned about all these commissions, that you have a lot of volunteers that represent a lot of clients who do it voluntarily and out of perhaps the goodness of their heart and loyalty to their government. And we're going to lose all those people, as I see it, because clients are not going to hire them, because there may have to be disclosures when the firm next door doesn't have such a problem, and the honest client is just trying to make an application and not influence anyone. And why go down the road where there'll be scrutiny and just simply because you hire a lawyer who's not even a legislator, and the legislators, it's even worse, but it's going to have significant ramifications, and I would like to take another look at it, a closer look, certainly.
Sure. I mean, I'm not sure in the regulations what we actually can do, because the legislature and the governor, in my view, just one person's view, wisely are now requiring much more fulsome and much more specific disclosure about who does business with people who are in the government. But be that as may, that's my own personal view. But, I think, Joe, to the extent that you're concerned about losing volunteers for appointed positions, frankly, my own view is that our hands are tied, because the statute does what it does.
They may be, but we don't want to make it broader than it is.
Dawn.
I just wanted to ask Monica, you had raised the fact that there were a number of commissioners that had offered comments on the regulation, including myself. So as we wait till the next meeting, are we holding the regulation as it is now? Are you going to incorporate those comments that you've received and redistribute them? What is going to be the process?
Well, hold on a second. One at a time, Rini, one at a time. I understand, but she didn't finish her point. So let Dawn finish, and then you can have the floor.
Okay, Counselor.
So just that as we wait for external comments, there have been a number of comments internally. And so how do we capture and reflect those comments and then also share them with others so that we're aware of what comments other commissioners have made?
Rini, do you want to say something? You want Monica to answer?
What Dawn was saying, I would be interested in hearing what the comments are, and maybe they should be circulated to all of us before the next meeting, so that would save time, and we could digest them and perhaps incorporate them in the future.
It's a good idea, and as you know, you guys all know, and I'll let Monica speak to it, her practice has been to do exactly what Dawn has suggested, which is to the extent that there are offline conversations, or for example, the staff had a conference call this past Monday, which we circulated a call-in for with the regulations, asking folks if you've got comments and questions, join the call. I think there was one person who dialed in, but be that as it may, I fully expect that Monica will, in whatever the process is, whether it's a conference call or you each have your own individual conversations with the staff, there will be a collection of those viewpoints for discussion in the next draft. And I'm confident that Monica will and the staff will do the best job they can to reflect in what are the next iteration of these regs are, the comments that commissioners have, and to the extent they're appropriate, comments from OCA and the LEC. Go ahead.
Well, my point really was, I would like to know what the comments are now or in the next few days, rather than have them incorporated and then someone isn't going to like them. If we all know what the suggested
Good idea. Let me make a
changes-
suggestion. Give Monica a call. I'm sure she will be happy to go through all of
Why can't we all have them?
We can. I mean, I'm
I
not
don't
really
need
sure
to
what
make a call. I'm suggesting that the comments from the other commissioners be put in the emails to all of us.
Or perhaps maybe we have another conference call where we
I think that's a good idea.
get availability and
Sure.
where it might work for more people, and then Monica could walk us through.
Right. I mean, and that's exactly the point of having the conference call, so that Rini, you and everybody else who has something to say, you can all hear your viewpoint. Look, here's the bottom line. Monica, I trust, will come up with something that makes sure that each one of the 14 of us know what everybody's perspective is on these regulations. All right? Okay. All right, so we will revisit this issue on the 27th of October. Unless there is any other business for the public session, I will now entertain a motion to enter into the executive session pursuant to Executive Law, Section 9419B. Is there a motion?
So moved.
Is there a second?
Second.
Commissioner Rosen, second. Okay. All in favor, raise your hand. Any opposed? Seeing none, we will now enter into executive session. When we complete our business in the executive session, we will return to a public session, and to the extent permitted by law, we will provide a summary of the actions that we took during our executive session. Thank you very much.
Go for it. You get the first turn in.
All right. We're back in public session. During our executive session, we considered and granted 3 applications from exemption from Public Officers Law, Section 73(8)B. We approved 4 settlement agreements. We considered a number of investigative matters. The Commission also agreed to adopt a targeted amnesty and compliance program for delinquent lobbying and client filings. We did this in order to promote disclosure and increase compliance by encouraging those lobbyists and clients who are currently delinquent into filing, so that the public has the transparency that the lobbying and client disclosure laws require. Unless there is any further business, I will entertain a motion to adjourn the meeting at this time.
So moved, Arroyo.
Second. All in favor? Judge Brett, second. All in favor, raise your hand. Any opposed? None. The motion is carried. Thank you, everybody. We'll see you on October 27th.
Bye-bye.